Okay, once again, everybody, thank you so much for joining in. A very good afternoon to all our attendees here today. My name is Shruti Sundaresan, and on behalf of the Rohini Nilekani Philanthropies, I'd like to welcome you all to this session this afternoon. And with that, I'd like to invite Nivedita from Pacta to take this conversation forward. Over to you, Nivedita.
My name is Nivedita, and I lead an organization called Pacta. Pacta is based in Bangalore, and we are a law firm that is exclusively serving the not for profit ecosystem in India. Pacta also does a little bit of research in philanthropy. And essentially, how we support nonprofits is in three ways. We provide a lot of legal services, right from incorporation to closure, as well as contracts, compliances, etc. We do plenty of research as they apply to nonprofits, and then see how capacities of nonprofits can also be built towards making the law a little less, scary to understand, and a little more accessible. We really believe that knowledge empowers, and that legal knowledge should not stay within lawyers circles. And so we do many things to bring that knowledge and make it available to as many people as possible. And so we really love Patik, and we love that Patik gives us this platform to put up all the resources that we've created. And Shamir was right in saying that, we have all of this and we don't know sometimes what to do with it. And it's great that some of our newsletters, some of our primers, some of our legal compendiums are available on the Patik platform. I do invite you to take a look, and if there are other pain points that you think we should be writing primers and on, please do let us know, and we're happy to take requests. Just as a heads up, Pacta is thinking of doing some work around GST for nonprofits. Our DPDP primer for nonprofits will be up soon on Patik as well. And we're also thinking of doing some work around labor and labor compliances for nonprofits. So this is upcoming work. Do stay tuned with the Patik resource library to sort of follow some of this. Without further ado, I'll dive right into the agenda for today. I've been asked to mainly look at two parts. One is the data protection legislation, and the second is on the name boards and website related compliances as they apply to not for profit organizations. Some of the resources on both these topics are again available on Patik, so please do sort of click onto that. I'll also link to it when I share the PPT with you. But really, let's go right into DPDP. So the data protection law, the the data protection law was passed in 2023. And with that, there has been a lot of conversation generally about how citizen data needs to be protected. Just to clarify, this is not the first time that India has a law like this. Our previous law, which is called the Information Technology Act of 2000, read with the sensitive personal data rules, also had a lot of guidance on how organizations that collect and process personal data, needs to sort of store this, collect this, and a lot of guidance around that. But still, when the Digital Personal Data Protection Act became passed in 2023, India had a standalone law very similar to other countries, like, for instance, the California law, I mean, in the US, as well as the European GDPR. And so India became one of those countries that had a federal level exclusive law dedicated to data privacy. And so some of these conversations have also percolated into the not for profit space. And absolutely right at that, because we do collect a lot of not for profit. A lot of personal data in our operations, and there are a bunch of compliances that one must keep in mind around this. I'll first talk a little bit about what some of the key concepts are, and then I'll also dive into some of the compliances under the DPDP, as well as some of the exclusions that the DPDP, or the exemptions that the DPDP has given. Just want to flag that the act has not yet been fully implemented, in the sense that while the act has been passed, the rules that actually operationalize some of these laws, they have not been finalized. So they have been again drafted and shared for public comment, but these have not yet been implemented. And so we're still waiting to hear from the Ministry of Electronics and Information Technology on when the act would be effective from. There is news every month that it's going to be implemented from the next month onwards, but I think we're all just waiting and watching as of now. So back to key concepts. Some of the jargon, you might hear these words a lot, and it helps to sort of know what these words mean. There are three words that you should remember. One is the data principle. The data principle is generally any person to whom the personal data belongs to. So if it's my data, I'm the data principle. The second concept is data fiduciary, and a data fiduciary is the person to whom the data is given. So this could be if, let's say, I'm a student studying in fifth grade in the Jeevan Bimanagar government school, and there is Akshay Patra coming in serving midday meal there, and I'm a data point in their data set. Then Akshay Patra would quickly become the data fiduciary, because they're collecting my data in terms of what my name is, what is my age, and maybe my home address, etc., as well as my date of birth. So because all of these personal data points are being collected by another entity, in this case it could be Akshay Patra, it could also be the state government, state of Karnataka, maybe several other non-profits. So whoever collects data from the data principle is called a data fiduciary. Now, the data fiduciary may keep the data themselves, or they may sort of pass this data onwards to other parties or other entities to process the data. So those entities are known as data processors. So sometimes Akshay Patra may collect the data, but because, let's say, it is running some sort of an impact assessment, it may be sharing this data with their impact assessment consultants. And so the impact assessment consultants may also become data processors, or they could also be data fiduciaries. Sometimes Akshay Patra may be using Microsoft and Microsoft Office tools to manage all the data that they collect from the students, right? So all of this data gets stored on the, let's say, the Microsoft Cloud, or any other Microsoft applications for managing the beneficiaries. And in that case, Microsoft would also become an intermediary. The next is really, what is personal data? Personal data is personal data. So any data that gives away information about the individual, then it would become personal data. So anything about the name of a person, his or her, or their date of birth, specific information on their biometrics, their blood group, their email address, their home address, all of this data becomes personal data, and it would need to be handled appropriately, and we would need to meet compliances under the Personal Data Protection Act. Now, the Personal Data Protection Act is very clear that it applies mainly to personal data, and it applies to data that is digitized. So, if you collect data and then you digitize it, then digitize it as in, like I said, either you make computer records out of it, you feed it into an Excel sheet, or you collect data on pen and paper, but then you're actually, using it to maintain an email list. So all of these would become digitization processes. And then DPDP Act applies to data which is personally identifiable, so personal data as well as digital data, right? So these are the two qualifications for a data to get attracted under the compliances of the DPDP Act. Of course, as we know, nonprofits have several channels through which we collect data. So if we are collecting data through surveys, if we have any other beneficiary databases, any sort of meeting minutes, if there are workshops and we are maintaining attendance, if we send feedback forms, any sort of donation forms, all of these become sources through which the personal data then, the digital personal data begins to flow into not-for-profits. And any of these activities, therefore, will kick off the requirement to comply with the DPDP Act. I'll quickly talk to you about consent and notice. These are another two concepts that are really important, especially in the context of personal data. So, usually, when we take data from somebody, the rule of thumb across all legislations in the world that regulate personal data is that we take such data based on the consent of the data principle. Okay, so consent is such that when we collect data from anybody, ये है कि हम we collect the data only after asking if it is okay to collect their data. So that is consent. हम data लोगों से collect करेंगे जब उनका okay मिला है वो data collect करने के लिए. So there are a few rules for consent, right? The consent must be absolutely free. कि उनको कोई मतलब जबरदस्ती नहीं होनी चाहिए कि उन लोग अपने डेटा हमारे साथ डिस्क्लोज करें. दूसरा ये है कि जो भी हम कंसेंट लेंगे वो एक स्पेसिफिक पर्पस के लिए होगा. हम ऐसे नहीं कलेक्ट कर सकते हैं कंसेंट कि हम आपसे डेटा ले रहे हैं और कुछ भी करेंगे वो डेटा के साथ कि ब्लैंक पर्पस के लिए, कि हम एक पेज में ब्लैंक पेज में किसी का सिग्नेचर लेते हैं. ऐसे नहीं होना चाहिए कि बट वी टेक द कंसेंट फॉर अ वेरी वेरी स्पेसिफिक पर्पस. We tell the people how are we going to use this data, with whom are we going to share this data, and how many days are we going to save this data, etc. Right? So these are only when consent has fulfills these rules, it is said to be given freely. Right? And then consent for taking the data, we're also providing our data principals with a notice that how can they delete this data if they want. If they want to raise a grievance, how can they raise a grievance? And if they want to file any sort of complaint or if they want to interact with the data principle, so kabhi kabhi aise ho sakta hai ki somebody has declared their blood group to be A positive, but they realize no, my blood group is not A positive, it's O positive. So they want to reach back out and correct the data in your database. And so it is important to also provide notice as to with whom they should file such a request. So two parts to data collection: one is consent and one is notice, right? So these are some of the basic principles of data collection. Let's say 2 to 3 minutes looking at what are the main implications for nonprofits that engage in data collection. So pehla ye hai, like we just discussed, that you should give explicit reasons why we are collecting this data, and the consent must be absolutely voluntary and it should be informed consent. So this is the first sort of requirement. And we should also ensure that we inform the data principal as to what we are going to do with their data, कि हम किसके साथ share करने वाले हैं. Are we going to process it for the purpose of research? Are we going to share it with our donors, etc. तीसरी ये है कि we only collect such data which is absolutely necessary for our purpose. ऐसे नहीं है कि अच्छा ठीक है हम ये भी collect करेंगे, हम actually education कर रहे हैं, तो हम वो रेशन कार्ड भी कलेक्ट कर देंगे, कास्ट का स्टेटस भी कलेक्ट कर देंगे, बीपीएल स्टेटस भी कलेक्ट करेंगे. So that should not be the sort of lookout. The expectation from the DPDP Act is that you collect only that such personal data which is needed for your particular program or requirement. Um, I just want to remind you here that there are certain exemptions, and we will talk about those exemptions in just a minute. Um, but broadly, remember that consent and notice is important, and some of this, and in how you sort of process this data must all be governed under a common data protection policy. तो हर एक नॉन प्रॉफिट के लिए एक मतलब डेटा प्रोटेक्शन पॉलिसी होनी चाहिए which governs how you collect the data, how you use the data, how are you collecting the consent, where are you storing the data, with whom are you sharing the data, and such other specifics. All this should get covered under a data protection policy. And the DPDP also expects that nonprofits or all organizations that deal with personal data have some of these in place. The next requirement under the DPDP Act is that for every data fiduciary to appoint a data protection officer. So every nonprofit is expected to appoint a data protection officer from their organization, and this data protection officer's email address must be published along with taking the consent, right, so that the person knows whom they can reach out to in case they want to correct their data or sort of have any grievance about how their data is being used, etc. It's important for you to remember. So, a data protection officer to be appointed. The next thing is to have data sharing agreements in place. One second. And ensure that if you have agreements, then the clause also, appropriately ensures that your partners who are going to collect your data are going to comply with the law, right? The third, another sort of internal measure you need to put into place is to ensure that your security measures, right? Access protocols, what are the firewalls you maintain in your information technology infrastructure inside your organization? All of this must be reasonably safe. Now, the law has not given any specific standards or any specific guidance. It only says you need to follow reasonable security measures. So, some amount of safeguards to ensure that you don't get hacked, your databases don't get breached, would be good enough to have things like two-party authentication, two-factor authentication, etc. would be useful. And in case there is a breach of data, you would need to intimate the data fiduciary, that is, whose data has been leaked, as well as the data protection board within 72 hours. Um, the last point is now we are going to then also talk about verifiable parental consent of children and persons with disabilities, because if you are collecting data of children or collecting data of persons with disabilities, then we need to ensure that their guardian's consent is taken or the parent's consent is taken. And I'll talk to you about that right away. So if you're collecting data of a child, please ensure that that data is you have permission to collect that data from the child's parent. Second rule is if you're collecting data from a person with disability and this person with disability has a legal guardian, then please ensure that the data gets collected with the consent of their legal guardian. So, as far as children with disability and legal guardian, these are the rules. There are some exemptions. The exemption to healthcare professionals, and please note that healthcare professionals are not anybody who is providing any sort of healthcare services. There is a very specific definition under the law as to who is a healthcare professional. And if we are collecting data only to render healthcare services of a child, then the need to obtain the parental consent has been exempted under the law. So this is one point to remember. Similarly, there is an exemption for educational institution. There is no specific definition of educational institution. It's only a broad definition. Anybody who imparts education, including vocational education, is supposed to be an educational institution. And so any educational institution that collects data from children, and if their processing is very restricted only to the educational activities of the institution or the safety of the child in the institution, or the collection is restricted only to tracking the behavioral data, or the processing is restricted only to tracking the safety of the child, then we are exempted from parental consent. So please remember that the exemptions are very, very narrow and very, very specific from obtaining a verifiable parental consent. So I think with this, I will share these slides, but broadly, these are the four or five principles that you should remember. Data security, ensure that you have good data processes in place. Second, and also have a policy. Second, have a good consent management. Please provide notice and take consent. Three, always be transparent about what is your data practices. Four, don't retain the data more than what is necessary. Five, always be accountable, which means appoint a data protection officer to ensure and drive the compliances under the DPDP Act. If you do need any additional support on complying with the DPDP Act, feel free to leave those suggestions in the chat, and we will see how we can respond to it. Before I move into the next, I mean, there's one question I want to ask you all. Do you think that the Shops and Commercial Establishments Act applies to CSOs? You can leave your responses in the chat. This question is mainly to to inform the next part of my presentation, which is on name board and website related compliances. Name boards are governed under three laws, right? It could be the specific act that you are, your incorporation act, which is if you're a trust or a society or a Section 8 company. All these three laws, whether it is a trust law or it is the Societies Act or it is the Companies Act, they expect that the nonprofit displays their name in a conspicuous manner. The second one is that there is a Shops and Commercial Establishments Act, and there are certain very specific requirements under that act. For instance, organizations in in Karnataka are expected to display their name board with 60% of the text being displayed in Kannada, and for like if you think about 100% of the board, 60% of the coverage in that board should be in Kannada, and 40% is to be in English, right? So like this, every state would have their respective practice. So please ensure that your name board requirement meets your localized requirements. Anytime the labor inspector wants to do a check, often that is the first point of the first barrier to entry, right? If that is not there, they'll start right from there. Even if it is a GST case or it is an income tax notice or an FCRA notice, they will start with why is your board not compliant. So please do pay attention to your localized requirement and ensure to comply with that. Secondly, as far as websites are concerned, if you are a trust or society, there are not too many specific details. However, if you are a Section 8 company, then under the Companies Act, you are expected to display your CIN, your corporate identification number, again very clearly in your website, also in all your letterheads, right? And if you also have the FCR license, that is, you have the foreign contribution registration, you are receiving foreign contribution. Under the FCRA law, we are also expected to put up the income and expenditure statement and the receipt and payment account and balance sheet on the website every financial year. Please do note that often the first point of entry for income tax inquiries as well as foreign contribution inquiries start from the website of an organization, and some of these are really important to maintain, and that's the place from which these authorities are getting details about you. So please ensure to keep these up to date and compliant. That's about it. Thank you very, very much for this opportunity. Back to you, Shruti.
Thanks so much, Nivedita. Thank you. That was really very, very well detailed and at the same time very succinct. So, thank you so much. Super helpful. And a big, big thank you to all our facilitators, Shamir from ICAM Fellows, Sharad from Sati Development Services, and Nivedita from Pacta. It was really informative and very, very pointed. So, thank you so much for keeping the information so brief and yet so impactful.